I'd like to introduce you to our moderator of the first session, which is Bartosz Sujecki from the Netherlands and from the law firm Van Diep en van der Kroef Advocaten. Bartosz is partner of the firms and, of course, the exclusive member of the Privacy Rules Alliance for this jurisdiction. Bartosz, before leaving it to you, a final note for our audience. Please feel free to use the Q&A or chat feature. We will use it to let you engage and interact with our experts during the session. So that being said, Bartosz, the floor is yours. Enjoy your session to you and to our audience, and I see you all after this first segment. Bye, everyone.
Thank you so much, Alessandro. Thank you for having me here. Good morning, good afternoon, and good evening for everyone around the world. We have here three very nice speakers which are joining us. We have HyeJin Hwang from DLG Corporation. That's a Korean law firm. She is a partner there and licensed patent attorney. And she has her degrees in French language and information culture studies from Seoul National University. And then we have Kelly Dickson from McPherson. Kelly, she is a partner, a managing principal from Australia. And last but not least, Trevor Fenton from Shakespeare Martineau, if I say it correctly. He is based in Edinburgh, and Trevor is a triple qualified solicitor in Scotland, England, and Wales, and a barrister and solicitor in British Columbia. We try to make a nice session on class actions on data breach. So when we have a data breach and there is a mass of people who are suffering damage, what can they do in the different jurisdiction? And we actually made a little case, just to a very simple case. Well, you have a company which is active in e-commerce and operating in this one country and processing and stores the personal data of a large number of users. And then there is an employee of that company, and he left the company and used authentication credentials issued during the employment to extrafiltrate personal data of a majority of the company's users outside the company. So he took the data at the end of the day. And this personal data is involved, and it includes names, emails, addresses, mobile phone numbers, delivery addresses, including apartment buildings, access codes, and purchase history. Now, the company is assumed to have reported and publicly disclosed the personal data breach within 1 day of becoming aware of the incident. So this is a quite simple case, and it's actually happening, and it could happen anywhere in the world. So the first question is, what is the damage? So if I may ask someone from Korea this time, how do you involve the damage problem?
In Korea, damage claimed in personal data breach cases primarily take the form of compensation for emotional distress rather than purely financial loss. In data breach cases, Korean law allows courts to award statutory damages up to USD 2,200 per person, unless the company proves that it was not a fault. However, where it is clear that no actual harm was occurred, courts will not award statutory damages. In assessing whether compensable emotional harm has occurred, Korean courts conduct a fact-specific analysis, taking into account multiple factors, including the type and sensitivity of the leaked damage, whether it is easy to identify the individual with the leaked data, whether third party assessed or were likely to assess the data, the scope of dissemination, the risk of secondary harm, the company's data protection practices, and circumstances of the breach, and the remedial measures taken to prevent further damage. For example, in a recent case, the court refused to award emotional damages where only email addresses were leaked, finding the identification of individual was difficult and that there was no concrete evidence of actual harm, such as increased spam emails or misuse.
Thank you so much. And how is the situation in Australia, Kelly?
Thank you. For us here, we would be looking at things like what is the type of data that has been compromised, and is that personal information or is it in the category of more sensitive information? So in this case example that we're looking at, the names and email addresses and mobile phone numbers, delivery addresses, those types of pieces of personal data could be used potentially for setting up maybe some fake accounts, or maybe sending the affected individuals a bit more spam than what they would be used to receiving. So the loss that we would be looking at there is what have they suffered in terms of any financial loss, or perhaps what have they suffered in terms of non-economic loss as well. So that would be things like anxiety, emotional distress. One of the things in the example that we're talking about here today, the data that is compromised could potentially include some building access codes. So maybe that's a little bit more concerning in terms of people's safety as well. And so we would be looking at things like mental well-being, their personal safety risk, and things like that as well.
In Europe, we have we have right now the discussion that it's very hard to enumerate, to say something, okay, you suffered this amount of damage because of a data leak. And I think it's the same situation when you look first at the data and what kind of data. But one of the issues that is dealt with is kind of the loss of control of your own data. Does this play any role, for instance, in the UK?
Well, a really good question, especially because with the UK having left the EU about 4 years ago now, there's the question in our courts of how much our courts are going to continue to follow European jurisprudence on issues that where EU law used to apply directly in the UK and no longer does. And we do have a bit of an answer on that from the Court of Appeal in England and Wales in a case, the Farley and Paymaster. So Paymaster is a company that administered pensions for, I think it was the Surrey Police Force, and they had an out-of-date database of addresses for pensioners. They sent out annual pension statements, and several hundred of them went to the wrong addresses. And so a claim was raised using the representative action procedure. It's basically an opt-out procedure rather than an opt-in procedure. But the big issue in that case was, is there sort of a minimum threshold of non-material harm that you have to establish in order to be compensated for it? So we really have to, I think, Kelly, you were sort of pointing at the difference between material and non-material harm. Material harm would be, direct financial loss. That's always going to be pretty difficult to prove that there's a causal link between the data breach and that financial loss. With non-material loss, we're talking about distress, etc. The issue there was, does there have to be sort of a minimum level of damage before it can be compensated? The Court of Appeal said no, and they explicitly followed the existing line of jurisprudence from the European Court of Justice, and they explicitly said there was no reason for Britain to go off and deviate from that line of cases, because they were cases that were decided under the GDPR when we had the exact same GDPR, and the UK's GDPR, at least as far as this went, hasn't materially been changed from the original EU version. So the English, the Court of Appeal said, look, we'll continue following that line of cases. It makes sense. It should continue to apply here. And the conclusion was, no, you don't need a minimum amount of non-material damage to make a claim. However, the mere fact of a breach is not enough to establish a claim for damages. You still do have to show, using objective evidence, that there was some kind of non-material loss, distress, alarm, etc., but it has to have actually had an impact. I think that leaves the floor wide open for advocacy on every single claim, because I don't think we have a really clear answer, a really clear test for, what is this distress that's compensable. It's going to have to be done case by case, and that causes a really big problem, I think, for group actions.
I mean, in the EU, as far as I'm concerned, they kind of make some standard damages that can be obtained there, and it's like 250 euros till 400 euros. It depends on the case, but it's kind of that amount that they standardize that. And if I hear it correctly from you, then it's in the UK you really have to look at each case separately and individually. Okay. And when we look at the proceedings, I mean, we have a case with lots of victims in this. How do you enforce such claims? Do you have to go individually? And I don't think for like 400 euros you will start a whole court proceedings, or are there some mechanisms in your jurisdiction that allow to start a sort of class action, Kelly?
Yeah, so there's a couple of different ways in Australia that a case like this could play out. The first way is through our Office of the Australian Information Commissioner, our Privacy Commissioner, and that is where individuals could make a complaint to the Privacy Commissioner to have effectively the Privacy Commissioner do an investigation and make a ruling in relation to that. If that was done that way, the financial results and the damages payments that are made are typically very small. They're quite low level, but that is a very cheap, easy, simple option for individuals to take to make their own privacy claim there. In relation to what the Privacy Commissioner could do, where there is a breach that affects a lot of people, the Privacy Commissioner can take that organisation to court and get some administrative penalties, some civil penalties. And in Australia, those penalties are becoming higher and higher as well. So that would be action that the Privacy Commissioner takes against the organisation. But in relation to class actions, which is what we're talking about here today, it is not unknown in Australia. It's certainly something that is growing, but for a class action in Australia, there needs to be a minimum of 7 people for a federal class action. Those 7 people need to have the same type of claim against the same company, the same defendant, and the claims need to all arise out of the same or similar circumstances, like a data breach happening to an organisation. We also, like Trevor said, we have an opt-out model as well. So if you are in that eligible class of people, then you can also join that particular class action as well. And so those class actions are typically run by law firms who specialise in class actions, and they would run that case. And then if they are successful, typically the way the damages would play out there is often by agreement, and it might be that depending on the different types of personal data that have been compromised and the types of damage that have been suffered, there might be different members in those classes who get paid different amounts of money, or it might be that they're paid the same tier of money, often by agreement.
Thank you so much. And how is the situation in Korea with the enforcement?
In Korea, damages may be claimed either through civil litigation or through the Personal Information Dispute Mediation Committee, which is an administrative dispute resolution body established under Korean law. First, from a civil litigation perspective, Korea does not have a US-style opt-out class action system for personal data breach cases. However, multiple data subjects can file a joint civil lawsuit against a company for damages arising from a data breach, and there is no minimum number of plaintiffs required. This makes it easier to share legal costs. That said, the result only applies to those who actually take part in the case and does not extend to others. In contrast, under the statutory group mediation procedure, at least 50 data subjects must jointly file an application. Once the application is accepted, the Mediation Commission publicly announces the commencement of the proceedings for at least 14 days, allowing additional affected individuals who did not initially apply to opt into the process. If the respondent accepts, in the end, if the respondent accepts the mediation proposal, the committee may recommend that the respondent prepare and submit a compensation plan for other affected data subjects who are not formal parties of the mediation, thereby enabling broader compensation beyond the original applicant. The recommendation is not legally binding and acceptance is not mandatory.
Thank you so much. Well, we have a system in the Netherlands that is kind of transformed a little bit on the EU in the new directive. We don't have really a requirement on about what a group is, how many people that a group has to have. But we introduced a couple of years ago a two-step procedure. The first step is a negotiation phase and a writ of summons, where a group is being formed. So you have to have a topic, for instance, well, data breach against TikTok or whatever. And then there is a waiting period, a cool-off period, you can kind of call it, of 3 months, looking whether other organizations might join it. But what's very crucial here is that you have to have a foundation in order to represent the interests of the group. And then the court is revising the admissibility of this case, saying whether group A is better suited to represent, or the foundation A is better suited to represent the group or not. In theory, this procedure is very well structured. In practice, it's because of those two phases that first you look at the admissibility and then you look at the content of the case. Then it's a very long proceeding. How is the situation in the UK?
Well, the regulator, the Information Commissioner, or soon to be the Information Commission, doesn't really have a role in private action. So they can take enforcement action, they can issue administrative fines, and generally speaking, they haven't been terribly active under the UK GDPR in doing that. Recently, a case such as this one, for example, it would be a little bit surprising to me if there was an administrative enforcement, simply because unless there was something fairly egregious that the company had done. From a cybersecurity perspective or like a sort of an organizational perspective that caused that breach, and maybe the commissioner wanted to send a message. But generally, administrative fines don't tend to be a particularly big feature here. For private actions, there are the UK's got 3 different legal jurisdictions within it. So England and Wales is one jurisdiction, Scotland's another one, Northern Ireland's another one. I can speak to both England and Wales and to Scotland. And they do operate a little bit differently with group action. So and we haven't had a lot of traffic in the courts in Scotland, so I'll mostly talk about England and Wales. There's the sort of the opt-in version is called a group litigation order. And the interesting feature about this is the individual claimants have to file their individual claims, and then there's an application to the court to create a group litigation order to resolve common issues that are issues that are common to those claims. Once that order is issued, then as an individual claimant, you can opt in and register your claim as one of those claims to be resolved by the group litigation order. So that's the opt-in version. The opt-out version is called a representative action, and you can have one claimant who files on behalf of anyone who's got a common interest that needs to be resolved by the court. And so that's the procedure that was used in probably the most famous case here, which is Lloyd and Google, which very briefly, Mr. Lloyd claimed that Google had bypassed certain features of Apple's Safari browser, and therefore scooped a bunch of data that it wouldn't have had if it hadn't gone around some of these privacy features. This litigation was not under the GDPR; it was under the prior act, the Data Protection Act 1998, which was the UK's implementation of the former EC directive. Anyway, but the issue, I think, the issue of whether it was a breach of that act would probably be the same issue under the GDPR. The big problem was there was a common issue, and the common issue was did this feature breach the Data Protection Act 1998? The problem is the assessment of loss for each claimant, and there were millions of claimants represented here, and that's where this fell down. What the court said is you could take a bifurcated approach, they called it. So that's a nice little piece of language. You could it would have worked if they had brought a representative action just on the issue of has there been a breach of the Data Protection Act 1998. But then they would have still had the problem of assessing the loss individually for each claimant. And that's really not suitable for a representative action unless you can point to something where the loss would be quite obviously a shared sort of it'd be the same issue. So for example, if the loss was we paid a fee and everybody paid the same fee and they all were denied the same service or whatever it was they paid for, then the fee they paid and therefore their loss would become a common issue to be resolved. But we don't have that with most data breaches. And I think in practice, that means group actions for data breaches, at least in England and Wales, are it's not that they can't happen, it's that they become impractical because the amounts involved are so small for each individual claimant. And so who's going to pay the cost of doing that first part of the action, right? The common bit of determining whether there's been a data breach, because the outcome from that cannot generate any damages. And therefore, litigation funders are going to be very reluctant to put money up to resolve that question when there will be no payoff.
Yeah, I think the situation is similar in the EU, or at least in the Netherlands, that the administrative part is the data protection officer is in such a case as we have having a small role or is only enforcing the administrative fees. Whether they do something, they're quite active, I have to say, lately, but not that much. When we look at the class actions and the possibility, then we face the same problems, that the courts are saying, well, we cannot determine the damage as such for a whole group, because each damage must be, considered individually. We had here, I would say, 6 significant cases against Oracle, TikTok, Google, Facebook, Apple, and Twitter, or X actually, which all had this question: what is the damage? And the first part, whether the group is admissible in these proceedings. And how is the situation in Australia, Kelly?
Well, it's an interesting thing, I think, for Australia when we're talking about class actions in relation to privacy and data breaches. Australia doesn't have a class action statutory tort that is available. So our class actions in Australia often need to rely on other civil causes like breach of contract, perhaps, or negligence by the company, whether there's been a breach of confidentiality. One of the things that we're seeing a lot of in Australia is whether privacy breaches and privacy issues are actually a form of misleading and deceptive conduct by the business. You know, where a business might say that they do certain things with personal information, but whether that's accurate or not, and whether that is true or not. So those are the types of damages that we would be looking at in Australia when we're talking about class actions here. I do know that one of the questions that has come in from the audience today is in relation to things like proactive settlements in some of these class actions that we're starting to see around the world, and whether a proactive settlement might actually kill a class action and mean that there's no damage that has been suffered because it's been, you know, compensated for already, or whether it opens up some other avenues as well. And so I would say that from the Australian perspective for that, a company making a proactive settlement would be helpful in terms of limiting some of the damage that has been suffered. But if the members of that class action, or if the individuals who are taking action themselves can also bear out other causes of action like a breach of contract or negligence, then that amount of the settlement money is one part, but there are still other causes of action that would also be available.
I mean, that it's in Europe, or in the Netherlands, the courts are very keen that a settlement is reached between the parties. They don't have to write the verdicts then, as of course. But it's the settlement part is also plays a big role in the Dutch class actions, where they actually force the parties to reach a settlement, and then the action is used sometimes as a, you know, as a catalysator, or how do you call it? It's a to speed up the process, you know, to enforce kind of a little bit that that settlement. It has been reached in certain cases, in other ones it isn't. And in Korea, I've heard that there is also such a proactive settlement measurement, and it's maybe even introduced in your laws. Is that correct?
Proactive compensation is not something that is written in the law, but actually in practice. For example, Coupang offered vouchers totaling $37 that could be used across its various services. But there are actually many criticisms that it is even a part of marketing to make users use their service more. But what I can say is that if it is written in their website that if a user uses this voucher, then the user is no longer entitled to claim for additional compensation. And if the user agrees with it, like clicking the button like I agree, then maybe it can prevent this user from claiming more damages in other procedures like civil litigation.
Thank you so much. And in the UK, how is the situation? Because of course we are lawyers, and our clients are very keen on the cost issue. How is it dealt with the costs in the UK?
Well, I mean, the general rule in England and Wales is that the costs follow the cause. So essentially, whoever loses ends up paying the winner's costs to some extent. It's not full cost recovery, but it's significant. Now, for if you're a member of a group litigation order, if you filed of course you filed your own complaint in the first place, and that general rule is going to apply to there's no difference compared to just a standalone case. If you file an action and you lose, there's a possibility the court will require you to pay the other side's costs. With the opt-out version, the representative action, I mean, the court does have the discretion to order non-parties to an action to pay the costs of a party in circumstances where that would be just. It's a little difficult. We haven't seen it happen with a representative action to the best of my knowledge, certainly not with data protection related claims. And it's a bit difficult to envision circumstances in which a court would order an opt-out party, so someone who has not opted out, to pay the costs of a claim that they didn't even initiate, right? That just, in most circumstances, wouldn't be just. However, if you do opt into one of these actions, you could, there's sort of two sets of costs involved here. There are the costs involved in resolving your claim, but then there are the sort of shared group litigation costs as well. And the general rule is going to be, you're going to be responsible as an unsuccessful claimant for your share of those group costs. There's usually, there's after the event insurance that is usually used to protect claimants against having to personally meet those costs. But it is potentially a real issue if there is no insurance, or if the litigation funder who promises to pay those costs on behalf of the claimants, if that funder becomes insolvent, somebody's going to be coming looking for those costs at some point down the road. And it's been there's been some discussion in the profession in England and Wales about how well informed claimants are when they join one of these actions, such as the one against EasyJet, for example. How well informed are they of the potential that they could, this is not a risk-free venture for the claimant.
The good thing then about the Dutch system is that the financial status of such a foundation that is representing the group it must be, is dealt by the court. They examine that, whether the foundation has enough sufficient financial resources in order to do that case and to bear the costs. How about in Australia, Kelly?
For class actions, there is some risk. So as Trevor was saying, it's not a risk-free venture, but generally in practice, the risk is actually quite low. The risk of an adverse court order for costs for ordinary group members who are part of a class action is typically low. They would have greater risk and bear their own costs for their own exposure to a cost order if they were taking active steps to become an active party, or if they opted out of the group proceeding and brought their own individual action, then they would also have some liability potentially for that. In class actions, the representative plaintiff or the applicant lead, the group leader, does have a meaningful risk of being exposed to an adverse cost order. But that's usually managed, as Trevor said, through litigation funding or through indemnities that might be given. And we do have some firms here who will run some no-win, no-fee type arrangements as well. So the risk is there, but it can be relatively low. When I mentioned before about actions that are brought by individuals to our privacy commissioner, the likelihood of exposure to costs there is even lower, really. And that's because it's not really a court-style jurisdiction there. So there isn't adverse costs that are ordered there. And that procedure is meant to be a very cheap and quick and easy thing to do anyway.
Thank you. And in Korea, we have 5 more minutes time, so maybe you can, shorten your answer a little bit. But how is the situation in Korea about the cost? Because I think that's a very important issue. So I would like to also go to Korea about that.
In Korea, plaintiffs have to pay the litigation cost upfront. It's always. And if the plaintiff prevail, they may recover a portion of those costs from the defendant within the limit permitted by law. But when there are a lot of plaintiffs all together in one case, they can share the attorney fee together. So, which is pretty much better to the plaintiffs.
Right. Thank you so much. Well, we have 4 more minutes left. I can just maybe to make a little bit of a sum up in that sense is I see that the data breach is playing an important issue, whether we are in Europe, and I consider UK as well towards Europe, not to the EU, of course, whether we are in Europe, we are in Australia, we are in South Korea, the issues are quite similar that we have to deal with. The solutions are a little bit different. I mean, we are looking, what is the damage? How can the damage bill be quantified? How can it be evaluated? This is, I think, a very important issue. And how to enforce this? Do we go through the Data Protection Commissioner, or are we doing a parallel Data Protection Commissioner, and a class action, an individual action? What is a group? How do we determine a group? I think those issues are quite extensive. And also, how do we deal with those proceedings? How do we deal with the negotiation phase? Do we want to reach a settlement agreement or not? We see all those features in every country that we discussed here. And I think that's very interesting to see how the same problems are dealt with on a slightly different basis, how the approach is slightly different. And of course, the cost of such proceedings. And I think what's interesting, or mostly interesting, is the fact that we know we have our national procedural system, and how to integrate this new form of data, new form of technique into our own national procedural systems. That's very interesting, and it's very exciting to see all those different views from all the different member states, all the different states. See, I'm coming from Europe, you know, I always say member states, so everybody's in the EU. So I would like to thank you guys for having us here, and to tell us all the different perspective from South Korea, from Australia, from the UK, which is really interesting. And I hope the audience had enjoyed a little bit our conversation, our presentations, and thank you so much.